you, the organizers, the Albanian Helsinki Committee, for selecting this challenging and very actual topic. We are living in a time when technology is revolutionary. And of course, we have, as professionals, we have a lot of dilemma about the balance between different rights. The topics selected for today are this balance that should exist between the right of expression and how it somehow impacts our private life. The whole conference, because there are some parallel sessions, is based on the role of media, but also as lawyers or as journalists, we should be concerned about the role of ethics in the whole picture. Without going longer, I would like to give the floor to Judge Pavli, who will be the first speaker to address this session. Judge Pavli, thank you for joining us. The floor is yours.
Mirëmëngjes dhe përshëndetje të gjithëve. Thank you very much, Valvona. Thank you for the invitation. The topic is, of course, has been of great interest to me in my professional life, even before joining the court. I'm very glad to see a lot of friends among the participants from Albania and the region. And I'm very glad to share this panel with my dear friend and colleague from the court, Judge Julian Shuking, who has very kindly agreed to give a presentation, and my dear friend and former Professor Mandro from the Tirana Law School. We go back a long time together. So without taking much more time with introductions, I would like to focus today. We've had a certain division of labor with Judge Shuking so that we don't overlap too much in terms of what we're going to discuss today. I would like to focus on the general approach in the court jurisprudence to the liabilities of online media and other online operators. Whereas the proper balancing, the more specific balancing between Article 10 and Article 8 interests will be done by Judge Shuking. But let me start with some general considerations, which I should clarify. They're not part of the case law as such. So these are views that I'd like to put out there in my own personal capacity. Of course, they're related to the case law. The first point that comes up in today's discussions on online media is there's a lot of comparison with the old regulatory models. And so does it make sense to regulate online like print, like broadcasting? Where exactly does it fit in this regulatory spectrum? And I wonder sometimes if posing the question in those terms makes a lot of sense. When we compare it to just print, for example, we may realize that we're comparing to something that kind of does not exist anymore. I mean, all the respectable print publications now have a significant online presence. And for all intents and purposes, those are online media. So those comparisons, I think, need to be treated a bit carefully, though I still think that there are good reasons to distinguish online from broadcasting in terms of the particular, especially heavy role that broadcasting still has, despite the development of the internet, for a large group of people, especially those above a certain age. How long that will last, we're not sure. I would like to recall the Council of Europe recommendation of the Committee of Ministers on a new notion of media. It's from some years back, but I think it remains entirely relevant. It has two important concepts. It calls for a graduated and differentiated approach in terms of the regulation of online and graduated in terms of the need for regulation, and differentiated in terms of how invasive such regulation should be. And so basically what it's sort of big technical words, but what I think the recommendation is saying is you have to see what it looks like. If it is an online outlet that looks like more like your traditional local paper, you treat it like that. If it's something that looks like a major broadcasting channel, then you might be, as a state, as a country, justified in more in-depth regulation. That said, I think there are a number of characteristics of the inline environment that are specific to it, and that might call for some sort of, at least they raise novel issues, and might call for a need for a somewhat different approach or different regulation. I'll highlight 4 or 5. I'm sure there are more in there that one can spend a lot of time discussing. But in terms of what we've been dealing in our case law, it's the following, I think, are interesting. The first is the question of anonymity. As we know, it can be abused online more easily than in the offline world. So it can be an issue, but it can also be essential, as the court has already highlighted in its leading Grand Chamber judgment in Delphi, that in less democratic societies, or where traditional media tend to be self-censored, anonymity provides a certain outlet for freer speaking. Then there is a question of permanence. Once you put something online, it tends to stay, number one, get out of your control, and number two, it tends to stay out there more or less forever. Well, forever is a big word, but permanently for a long time. And that is an issue that is specific to online, because it's also very easily accessible, even if it's older information. And this issue of permanence have given rise to new developments, including, for example, the question of the so-called right to be forgotten, which will be discussed in greater detail by my colleague, Judge Shuking. There's a question of potential reach and harm posed to other people's rights. Since access is greater, it's universal and immediate, it may mean that the potential harm to the rights of others is also more significant. However, here I would also like to draw a caveat and say that we have to be careful here, because it also may depend. If it's one thing when you look at the big social platform, and it's another thing if it's a social media that is more or less like a local newspaper with a limited following. So they don't all come in the same size. Then there are, of course, the challenges of jurisdiction. The internet is borderless, and that means that offending sites with unlawful content in one particular jurisdiction are often hosted on servers outside the jurisdiction, and quite likely also subject to very different regulations in terms of what is legal and not. And so this raises the importance of self-regulation, I think, and also collaboration with a private platform. So between governments and private platforms, or social society in one place and the platforms. And finally, there is the problem of the challenge of suppression, that it is easier on the internet to evade restrictions, especially for those who are repeat offenders. Let me move now to my second point, which is the case law of the European Court on the liability of online operators. So again, not on the actual specific balance in between 8 and 10, but the sort of the broader framework in the regulatory architecture that has been put in place by member states, and how the court has related to that. Well, I think the first thing to do here is that we need a distinction between what's one could call your own content, so the content produced by the online media, and user-generated content. With respect to own content, I don't think that we have seen any major changes of approach. They are treated like all media producing editorial content, and that tends to attach a fairly high level of liability. They're responsible for what they say. What is more complicated is the user-generated content, so third-party content, all the little comments that you see below an article. A lot of media allow them these days. Some do not, but a lot do. Anything you see on Facebook, on Twitter, on YouTube, any platform, the great majority of it, it's not the platform's own content. The whole point is that they enable others to share. So all of it is third-party content, and therefore raises questions of third-party liability. And so this was one of the early dilemmas of the internet. This third-party content, do we treat it like the regular editorial content? And that means the outlets are 100% responsible, which would be a very huge burden for them. Just to give an example, every minute on YouTube, there are thousands of hours of video content posted by thousands or more people around the world. So every minute. So imagine the liability of such a platform having to look to verify the legality in 2 different jurisdictions of every single one of those pieces of video content. So that's the magnitude of the problem, and for that reason, liability has been limited in return, initially at least, in terms of third-party content. And that's why when the judgment of the Grand Chamber of the European Court of Human Rights in Delphi came out, it was seen as potentially undermining this big European compromise, which was set out in the Electronic Commerce Directive of the European Union, that limited or conditionally limited liability for third-party content. I'm not going to say a whole lot on Delphi, because I have no doubt that it's familiar to this audience, and we've discussed it in many previous meetings, at least that I've been part of. So, but if you have questions on Delphi per se, I'm happy to come back to it. But basically, the court said that it was permissible in that case, it was no violation of Article 10, to hold these Estonian newspaper liable, even though it acted when someone complained. But because it did not act quickly on its own initiative before anyone complained, it was held liable by the Estonian courts, and the Grand Chamber said that was okay under the circumstances. So what was the compromise that at least some people saw that Delphi having potentially undermining is the so-called safe harbor clause of the e-commerce directive, which says that there is no liability unless and until there is actual knowledge. So the website somehow receives actual knowledge of illegality and does not take expeditious, that's the word in the directive, action to remove the content or block it once it receives actual knowledge. So in other words, that means that if they do take expeditious action once they have received knowledge of illegality, then they are not liable. Delphi set out a number of important criteria, the nature and context of the comments, the measures taken by the media to prevent or remove unlawful comments. So did they act? How quickly? The liability of the actual authors. So again, we're talking here about third-party content. So there's also the option of going after the third parties who were the authors of this content. The consequences of the domestic decisions for the media, was the fine too high? Was it something that's going to send them bankrupt? And then there was an important caveat that the Grand Chamber made in Delphi. It said expressly, it sort of limited the scope of its own ruling. And they said, this is a ruling about a major commercial online news media in one country. This judgment did not concern, and I quote here, other internet fora such as a social media platform. So the court basically said that will be for another day to decide. And I think that that day has not yet arrived. We still have not had cases involving the third-party liabilities of the big platforms, the Facebooks, the Twitters, or whatever it is, the TikToks, other things where the kids used to be these days that I don't even know the names of. So, but you get the point. The point I want to make today is that you know, sometimes a lot of the attention goes into what was said in Delphi, but not enough is said about our case law following Delphi, which is not of a Grand Chamber level, but it is at the chamber level, but it is quite relevant and important, I think. And the first case that I want to highlight is an Hungarian case. Now, Hungarian case is, I love the country and I spend time there, but their titles are impossible to pronounce. So I'm going to call it MTE, which is the name, the abbreviation of an association, and index.hu versus Hungary. And since it's a difficult name, let me also mention the case number 22947/13. So this was a judgment from 2016, and the court made the following important points. First of all, it distinguished from Delphi in saying Delphi was about hate speech and incitement to violence, and this case, the Hungarian case, is about commercial business reputation. Number one. Number two, even though the speech was offensive and vulgar, so about a certain business entity, it did not constitute clearly unlawful speech. So that's an important point. I think it's an important standard. There was no clearly unlawful speech. And certainly it did not amount to hate speech. The court thought that it was of some relevance that there was a distinction between the applicant in Delphi, which was a large media outlet with economic interests, and a non-profit association, which was the applicant in the Hungarian case. And then what I thought it goes to the heart of the matter. The court said, it is not for us to assess a regulatory model as such. In other words, what kind of general approach a country should take in regulating its online media. That's for each country to do. But if accompanied by effective procedures allowing for a rapid response, the notice and takedown system could function in many cases as an appropriate tool for balancing the rights and interests of all those involved. So basically the court is saying this big compromise that is implemented in the Electronic Commerce Directive, known as notice and takedown. In other words, you're not liable until someone puts you on notice and unless you take it down, will in general be okay for conflicts between speech and other people's rights that do not rise to the level of hate speech or incitement to violence. And this approach, I think, has been followed by and large in at least 3 other cases. I'm just going to mention them quickly because there's no time to really dwell on them, but I'll just mention them for your interest. One is a case known as Tamiz versus UK. This was a decision from 2017. It was brought under Article 8 of the convention, so not 10, but 8, and someone at the national level complained that the decisions of the national courts violated his right to reputation. This is, to my knowledge, the only case that involves a major platform, because the action at the national level was versus Google, and the court, our court, dismissed the claim as manifestly unfounded, basically agreeing with the national court that there was no serious harm to reputation. This was a very small blog with a small following, and that Google had acted within a reasonable period, which was in fact not so short. It took Google several weeks. A similar case is PIL versus Sweden, PIHL versus Sweden, another decision from 2017, a similar claim under Article 8. And this was a case when offending comments stayed on the blog of a small nonprofit for 9 days and were removed 1 day after the applicant complained, so within 24 hours. And then another one that may be of interest, Hoines versus Norway. So that's HOINESS. This is from 2019. It's a case on where I happen to be part of the composition. And it was about vulgar and sexist remarks about a well-known female lawyer in Norway. And the court again found no violation of Article 8 because the platform had an established system of moderators who monitored content and removed the actual offending comments within 13 minutes. So they had a monitoring team, and within 13 minutes, they were able to remove it. So what's the lesson here? The lesson is that, you know, you may not have strict liability as in Delphi, but the court will want to see, and let me quote it again, the language from the Hungarian case, effective procedures allowing for a rapid response. So if you want to benefit from the notice and takedown as an online system, you need to make sure that it works, you have some ability of monitoring, and that you act relatively quickly. What exactly is relatively quickly? It may depend on many circumstances. Now, I think I'm close to the end of my time. So extremely telegraphically, let me mention two other lines of case law. I'll just mention the names. There's a growing law on the blocking. We haven't discussed blocking of online content, only post liability. But if you're interested in blocking, you should look into 4 cases that were delivered, 4 judgments that were delivered against Russia on 23 June 2020. They're all on different forms of blocking. They are known as Karitonov, Flavus, Bulgakov, and Engels, and you can find them on the court's website. What are the standards, which are much more stricter standards that the court applies to.
Can you start your presentation because it's your turn now?
Sorry, I didn't hear that very well. I'm told, I understand I'm told to wrap up.
Yes.
Okay. So there was before my last sentence, which was there are models of national legislation and as well in Germany, France, and the UK. And if you want to look at an interesting constitutional jurisprudence, you can look at the strike down by the French Constitutional Court of the Avia law. This is a very recent judgment where the French Constitutional Court struck down a law that tried to impose much stricter regulation on online operators. And before I finish, I made a big mistake of not thanking, of course, the organizers of this event, the Albanian Helsinki Committee. So my apologies, Irida, for that. So thank you very much to the Albanian Helsinki and everyone else in the organizing team. And apologies for the extra time.
Thank you very much. Thank you very much, Judge Pavli, for the very concise presentation and the very interesting developments you shared with us. I think colleagues, me included, would really appreciate if you could share in the chat the cases you mentioned, or any website or link that would be helpful for reading what you think are the standards or some leading decisions in the area. So if making a summary of your presentation, we understood that the right freedom of expression, it's not an absolute right. It should not be taken for granted as well, and it should be a specific given based on the developments of the society in specific areas, like the digital one we are living right now. So thank you again for sharing with us all those interesting issues. Before giving the floor to Judge Shuking, I'd like to inform you that we have a short survey. I would really appreciate your input. So colleagues should help me in this moment in sharing with you the first question, concerns about privacy in internet. You just see in your screen poll 1. Do you all see it? Okay, I would invite each of you to give your contribution to this first question. We'll have 2 other ones after each of the sessions. So please, a few seconds of your time to give your opinion about your concerns about privacy on the internet. And we'll have in real time the results of these concerns. The internet has been a very important part of our life. We can't live anymore without our mobiles, without checking, without buying online, with the pandemic right now. But also we have a lot of concerns in the area about our information being stealed, or even not having quite enough information about how to use specific forums, or even the privacy or the information we share with others, or even the purchases we make online, how the site will further track the private information, the personal information we put in that. So I think our colleagues will help with the processing of the information. And then my colleagues inform me that only 23 participants have contributed. I see 37 attending the session. So I'd really appreciate if, in order to have a reliable result on the question, we all have our concerns about our relation with the online media. Okay, we have the poll results. So with the majority of percentage of voting, with 56%, we have, I don't know how information will be used, followed by someone might steal the information. Then my privacy have violated in the 3rd place, and with 4%, the letter D and E of the poll. So thank you for your contribution. Now it's time to give the floor to Judge Shuking, who will be sharing with us the latest development of the case law on the issues of the private life. The floor is yours, Judge Shuking.
Thank you, ladies and gentlemen, dear friends. First of all, let me congratulate you with organizing this media conference and with its impressive and ambitious program. It's a privilege for me and an enormous pleasure to join you this morning. to share with you some thoughts on how to balance competing interests in the context of a digital era. I would, of course, have preferred to meet you in person, but let's hope that there will be an opportunity in the near future to do so. Turning to the topic of my presentation, balancing rights in the digital age. Well, needless to say, it's said already that due to technological developments, we live in a completely different world than 20 years ago. The online world has almost taken over of the offline worlds. The omnipresence of internet and telephone communications and social media in our daily lives has transformed social, political, but also the legal landscape. And even for cautious technophobes, which shun internet and social media, most things we do now, both online and offline, leave digital traces. And this phenomenon creates, of course, challenging legal questions. And these questions will, of course, be raised on the national level first, but some of these have already reached the Strasbourg courts. And as time is limited, I will confine my presentation to cases on balancing freedom of expression with the right to respect for private life. And in that respect, I would like to stress that the court has said that the outcome of the balancing exercise should not vary as to whether the complaint was lodged under Article 8 or 10. Just a few remarks on the concept of private life. As you know, the court has adopted a very broad understanding of the concept of private life. It covers multiple aspects of the person's physical and social identity, including gender identification, information about a person's health or ethnic identity. And it also includes a person's reputation and personal honor, although the court has said that in this respect, an attack on a person's reputation must attain a certain level of gravity in order to fall within the scope of Article 8. It also includes elements relating to a person's right to his image, which means that photographs or videos fall within the scope of Article 8. And moreover, the right to protection of one's image presupposes the individual rights to control the use of that image, including the right to refuse publication thereof. An interesting question, Darian mentioned it already, is whether the concept of private life also includes the right to be forgotten. And I will come back to that question later on in my presentation. Although the convention stipulates that the right to private life may only be interfered with when foreseen by law and with a legitimate aim, and where it's necessary in a democratic society, of course, also this right is not absolute and may clash with other fundamental rights, such as the right to freedom of expression. Also a few words about the scope of this right, the right to freedom of expression. Well, as you know, the court has consistently held in its case law that this right constitutes one of the essential foundations of a democratic society, subject to the limitations in paragraph 2 of Article 10. Freedom of expression applies not only to information and ideas that are favorable, received, or regarded as inoffensive, but also to those that offend, shock, and disturb. And the court has reiterated many times that this broad scope of Article 10 is considered necessary to support pluralism and tolerance and broad-mindedness. Without a democratic, there is no democratic society. For the same reason, the need of restrictions of freedom of expression must be established convincingly in the form of relevant and sufficient reasons. And a particular high level of protection is accorded to freedom of expression in two fields, namely political speech and where it concerns matters of legitimate public interest. Matters of legitimate public interest may, for instance, involve the functioning of the judiciary. Perhaps you remember the case of Kudashkina versus Russia. That case is about a judge from the Moscow City Court who in an interview publicly criticized the functioning of the prosecutor's service and the courts in a corruption case. And she was disciplinarily removed from office for raising that issue. And the Strasbourg court in that case held that her dismissal was a disproportionately severe penalty, which moreover was capable of having a chilling effect on other judges wishing to participate in the public debate on the effectiveness of the judicial institutions. So in the particular circumstances of that case, the court found a violation. The vital role of the media in facilitating and fostering public rights to receive and impart information has also been repeatedly recognized in the court's case law. It's considered that were it otherwise, the media would be unable to play its role as a public watchdog. This case law has been developed, of course, in the context of what we now call traditional media, information shared by journalists in newspaper articles and on TV and radio. And nowadays, the question may arise whether who and what constitutes a public watchdog in the context of a digital era. The internet does not transform, of course, all bloggers and popular users of social media into recipients of privileged Article 10 protection. However, it does blur the line between journalists and others. And at this point, it's also worthwhile to reiterate that the court has made it very clear that a high level of protection afforded under Article 10 of the Convention to journalists when raising issues of legitimate public interest is subject to the proviso that they act in good faith and on accurate factual basis and provide reliable and precise information in accordance with tenets of responsible journalism. In this respect, I might remind you of the Grand Chamber judgment of Stoll versus Switzerland of 2007, in which the court, referring to this element of duties and responsibilities included in the second paragraph of Article 10, held, and I quote, in a world in which the individual is confronted with vast quantities of information circulated via traditional and electronic media and involving an ever-growing number of players, monitoring compliance with journalistic ethics takes an added importance. In this respect, a clear distinction exists between journalists on one hand and bloggers and ordinary members of the public publishing on internet fora and discussion boards on the other, as the latter are not bound in principle by codes of ethics of journalists. Here there's another question related to our digital age arises. What should be the interpretation of the elements, duties and responsibilities included in the second paragraph of Article 10 in this context? Well, answers to this question are being developed. Darian already referred to the Delphi case, in the famous Delphi case. And the court indeed was also in that case confronted with the question of duties and responsibilities of an internet news portal. I will also not go further into the merits of this case, as you all know about it. And Darian has also explained that there's follow-up case law, which is important to pay attention to as well. I would just like to raise two things. What the court has said in this Delphi case is that internet news portals must in principle assume duties and responsibilities. So there's an explicit reference to this aspect from the second paragraph of Article 10. And it said also, it also stressed that the protection of fundamental rights online should be the same as the protection of those rights offline. Well, allow me before concluding to say a few words on this question whether there exists a right to be de-referred, or usually referred to as right to be forgotten. In a digital age, it appears to be very difficult to escape from your past. As I said before, most things we do now, online and offline, leave digital traces. You know that in 2014, the European Court of Justice in Luxembourg, the Court of the European Union, delivered a judgment in the Google Spain case. In that case, the court held that EU data protection law provides for a right to be forgotten online. According to the Court of Justice, this right extends to inadequate, outdated, irrelevant, and excessive data that applies where the search results link to lawfully published content which remains available elsewhere. And the court in that case did engage in a balancing exercise, and the right to be forgotten was not considered an absolute right. However, it's considered that the right to privacy and data protection override as a rule. That's not only the economic interest of the operator of the search engine, but also the interest of the general public in having access to that information. Well, should be less protected than the privacy of the person in the context of the elements that I have just mentioned. The Strasbourg Court has not yet had a chance to examine the same factual situation as in the Google Spain case. It has, however, tackled the question of removing materials from newspapers' internet archives. And I will give you 3 examples of that very briefly. The first one is the case of Times newspapers. It was a complaint lodged under Article 10, in which it was stated that the British Internet Publication Rule, which requires that a notice should be attached to archive copies of materials that had been qualified by courts as defamatory, infringed the right to freedom of expression. But the Strasbourg Court in that case considered first that, well, the primary function of the press is to act as a public watchdog, as I said before. It has also a valuable secondary role in maintaining and making available to the public archives containing news that has previously been reported. It further noted that the margin of appreciation afforded to states in striking a fair balance between competing interests is wider where it concerns news archives of past events than when it concerns reporting on current affairs. And applying the principles in that specific case, the court considered that, like the Domestic Court of Appeal, the requirement to publish an appropriate disclaimer to the article contained in the Internet Archive constituted a proportionate and therefore justified interference with the newspaper's right to freedom of expression. Another case, which is a little bit a mirror example of this case, because it was a case in which a complaint was lodged under Article 8. It's a Polish case. It's a case from 2013, also a very difficult name to pronounce, but I will send you the details of these case law through other channels. In that case, the applicants alleged that the fact that domestic courts had not ordered to remove the article from the newspaper's archive, although they had won the defamation lawsuit against the newspaper, was a breach of their Article 8 rights. And the Strasbourg Court in that case found no violation. It held that the judgments by the domestic courts declaring that the article to be in breach of the applicant's rights had not created a legitimate expectation that the article should be removed from the newspaper's archive websites. Also, it agrees with the domestic court that it was not their role to engage in rewriting history, ordering removal from the public domain of all traces of publications which have been found defamatory by final judgments and decisions. But it said in such a situation, a comment on the article's webpage informing the public of the outcome of the defamation proceedings was sufficient. Then another case, the third case I would like to mention is a judgment of 2018. It's a German case. The name of the case is ML versus Germany and WW versus Germany, but I also sent the details. It's a case in which the applicants sought protection of their right to privacy as their prison sentence for murder of a very popular actor had come to an end. And they sought to require 2 newspapers and a radio station to remove from their internet archives references to reports where their crimes and names were discussed. At least they wanted to have their full names removed from these archives. And while the lower courts in Germany upheld their claim that there was a violation of their right to privacy, the higher German courts upheld the appeals introduced by the media on the ground that the lower courts had not taken sufficiently into consideration the right to freedom of expression, and in this context, the public's interest to research past events. And referring again to this margin of appreciation of the domestic authorities and the fact that they had struck a fair balance between the competing interests at stake and adduced relevant and sufficient reasons for their decisions, the Strasbourg court found no violation of Article 8 in that case. The court explicitly noted that this case is different from the Google Spain case that I just mentioned, as the latter concerned the operation of a general search engine, while in the present case concerned archived press publications, which were not traceable through this general search engine. It further observed that the applicants, when requesting the reopening of their criminal proceedings a few years before their release, had actively sought contact with the media themselves and had provided documents to the media. And the court had that also for this reason, the applicants at the moment of their release could not be regarded as purely private persons, because there had been already a lot of information and discussion in the media before that moment. And it further held that as a consequence of contacting and providing information to the media, they could only have a limited legitimate expectation of having a right to be forgotten. So these are elements that the court in this case law has taken into account. Darian just informed me that pretty soon there will be another comparable case in the case against Belgium. So, well, look at HUDOC in the coming months if there will be further developments in this respect. I just would like to make some concluding remarks. From these case law examples show that the court has recognized the risk that internet is posing to data protection and privacy rights. It also demonstrates that those transmitting information through the internet, including those who run portals and internet platforms, must assume duties and responsibilities. At the same time, however, it appears from the court's case law that the existence of a risk posed by internet on privacy rights does not justify the downgrading of the fundamental right of freedom of expression. And it does not prioritize the right to be forgotten without due consideration to the potential wider impact on the freedom of expression. Internet and social media provides us with many opportunities, but also a lot of legal challenges. And as domestic legislation is being adopted and adapted to respond to these challenges, I have been informed that you are in Albania in the middle of this process. One can expect the coming years a considerable development in case law on balancing rights in digital era, both on domestic and European level. And hopefully we might have a chance to meet again in a couple of years to discuss the case law developed by then. And for now, I would like to thank you for your attention.
Thank you very much, Shuking, for sharing with us several key messages, especially on the roles and responsibilities of the journalist and several operators based on their specific field of operation. We understood that it takes a lot of efforts to find a balance between the freedom of expression and the right to private life, without taking out the importance that the right of expression has in a democratic society. The right to privacy takes a lot of relevance as well. We have the right to be developed in an autonomous way. You said the very interesting topic of the right not to be forgotten. It's really interesting to go further and see how it impacts the limits of freedom of expression for the journalist. But on the other hand, I would like to put an emphasis on a very important message you shared with us regarding the primary aspect that the journalist might take into consideration in deciding whether or not to share some private information online, except for the case when there is public interest in that discourse. And that is very important and a very key message that we all need to consider and take into consideration. Thank you very much again, and we'd really appreciate if you can share with us the cases that you mentioned via chat. Again, for the participants, I would really like your contribution for the second question of our short poll. Please, colleagues, concerns about freedom of information in internet. You have three options, A, B, and C. The internet should be an open space, free from control of government and business. There is a need to regulate the internet. Security in internet is more important than privacy. You are encouraged to give your contribution to this short second poll. All the questions are relevant and somehow challenging in trying to give the specific place to each of the actors and also understand what are the limits of relative control by the government or a completely free control internet or a balanced one. We have to wait a few seconds about the results of this second poll. Sometimes we all feel affected by the relation that is created. We live in an area of development technology with a lot of dynamics, but we've seen a lot of risks like mass surveillance or communication interceptions and actions that, if not controlled or regulated accordingly, can put a lot of risk. So we have the results. With 57%, we have there is a need to regulate the internet. And followed by 32%, the internet should be an open space free from control of government. And the third one, the security in internet is more important than privacy. So thank you for your contribution. We'll have the pleasure to hear for the majority of us, our dearest Professor Arta Mandro. For those who don't know her, Professor Arta Mandro is a full-time professor at the School of of Magistrate, former responsible professor for the continuous training at the school. Professor Mandro, we are really happy to have you here today and to hear your message and short introduction about the role of the School of Magistrate when it comes to being novelty in the digital era. The floor is yours.
Thank you very much, dear Valbona, Judge Pavli, Judge Shuking, distinguished participants. As Valbona introduced me, I am a full-time pedagogue in the School for Magistrate. I used to be a pedagogue for some of the participants here, but it doesn't mean that I am too old. I am really glad and I really accepted fully voluntary the invitation made by the Helsinki Committee to participate in this event, in this activity, and be here on behalf of the School for Magistrate, on the behalf of the director of the School for Magistrate. But it is a real privilege for me personally to share with you the role of these important institutions on the issues that we are discussing today. School for Magistrate is established by law as an important, let's say, part and actor in training of judges and prosecutors in the country. This is an institution where training is an aspect that put together judges and prosecutors, the new one and the senior one, the experts that we share and we select in a very sophisticated way, put together difficulties in understanding the new legal basis, the new standards, through making evident the novelties in the jurisprudence of the European Court of Human Rights and European Court of Justice. All the standards are part of this engineering of training and teaching methodology. School for Magistrate is a place where effective debate is happening in order to increase the professionalism, independence, and impartiality of important actors in the justice system, like judges and prosecutors are. Today, all our lessons and training activities are taking place online. We appear in our private spaces and environments. We as teachers, our experts, our candidates, and why not even judges and prosecutors. And this is a demonstration how things are happening and how we relate this digital environment and area in a space of teaching methodology in the School for Magistrate. This painting that you see behind me is always behind me when I teach. And I do remember that at the very beginning, because of the COVID, when we tried to introduce these new techniques and methodology of teaching, it used to be a lot of resistance by the candidates. But we try to explain them that this is an approximation of problem solving and how we can use the technology to benefit and to let's say to improve our communication. I do remember that I had to tell to my students that time, 1 year before, it is not a long time before, but just 1 year before, a comparison to make them understand the importance of new area that we are living and the importance of understanding the new challenges that everybody of us have to affront nowadays. And in order to make them feel good and familiar, and being a professor of the family law, my comparisons were related to this field. I try to tell them the difference between breastfeeding from one side and those that we mothers call artificial milk, and say that, of course, breastfeeding is something that can't be substituted. But we need this artificial milk. We need this technology. And of course, it exposes us to new challenges. The adequate law, the adequate standards established have the possibility to show their values themselves when they are confronted in the case law, in the jurisprudence. All judges and prosecutors of the country, and as well as other legal professionals, consider the School for Magistrates as their home, because this is an institution that provide a specific food important for increasing their professionalism, to make them feel playing an advocate role toward the challenges they have, judges and prosecutors have to affront in their daily life cases. In order that our judges and prosecutors be the main actors in the protections of the rights and freedom, they should be steps forward in understanding the essence of possible violations and all the developments happening in Albania and outside Albania. The digital age, this is how we call more and more the time in which we live today, even without properly understanding the meaning and the consequences. We are all online, and no one had imagined this a year ago. What development dictated by necessities has the new forms and platforms of the communication, where the vulnerability of rights can be exposed to an unconsolidated, let's say, standards in place in a small country like Albania, and making privacy even more fragile with or without intent. I solemnly swear that while performing my duty, I will always remain faithful to the Constitution of the Republic of Albania, to the laws in force, and I will respect the rules of professional ethics. This is the text of the oath of the judge in Albania. I want to see, as a professor, as a teacher, I want to see this oath text not only as a text, but as a real obligation, as an everyday duty where judges and prosecutors analyze themselves, their actions towards their colleagues internally as an organization, as a justice system, and from the other side, how do they play their role and due to prevent and protect the third parties? In the main law on the status of judges and prosecutors in Albania, there are, the word ethic is mentioned 64 times. It is quoted 64 times, just to bring into attention of this important category of actors, that ethical is the core of conducting properly the duty. An effective and independent judiciary is essential to justice and the rule of law. Judges must be involved in setting, respecting, and adapting high standards of conduct and must have a position that respects independence, impartiality, and honesty as judges. And this is a matter of their everyday life, and this is a matter of their everyday reputation, and it is a matter of everyday role of an institution like the School for Magistrates. Before coming here, I had the possibility to have a look at the two main programs that we had in the School for Magistrates. They are called initial training programs and continuous training one. In both of them, professional ethics is part of. But I try to see much more attentively the initial training program and to see how in this curricula are put it the new dimensions dictated by the digital area. And the same I have done in the continuous training program. And let me say to you that it is always a place for improvement, because as you distinguished judges mentioned, even the jurisprudence of the European Court of Human Rights is developed. That means that this is a persistent role to be played properly through building curricula, through selecting experts, through providing materials, and through changing the behavior, the ethical behavior in a narrow and openly minded system of judges and prosecutors in Albania. I think that in these areas where expertise can play an important role, another key element is to put together, to work together, to share knowledge and difficulties with different actors, like journalists, for example, and bring together these actors in order to provide to judges and prosecutors all the sides, all the sides of the problems that maybe very soon, maybe even today or tomorrow, they have to affront in their everyday work. I thank you very much for this opportunity. And let me highlight that the school is here. It is a strongly established institution. The school has a lot of challenges, and there is room for everybody to improve the justice system in order to play its adequate role in this new area and in the new area of digitalization. Thank you very much.
Professor Mandro, I'd like to thank you for your short introduction and also key messages you shared with us. We all are aware of the very special role the School of Magistrates has in the framework of the new reform, justice reform, and with the very extended mandate and the new status of a Judicial Leadership Institute, we are expecting that more and more you bring the best in the system for judges and for prosecutors. You mentioned a very important message, the need for consolidation of standards and also for an open dialogue between different stakeholders. Fortunately, we have media judges in our courts, and that is an opportunity for establishing bridges of communication, a continuous one between journalists and media judges. Of course, the School of Magistrates has always had a leading role when it comes to the novelty, as you showed, in shifting immediately into online initial training and also continuous training without losing just not a single day. When it comes to increasing the knowledge and strengthening the professionalism of judges and prosecutors, while we all know that we need a lot of independence, impartiality, and let's say that when it comes to not only freedom of expression, not only to the private life, those are not just matters of law. Those are matters of ethics and morality. So that is very important. Even those are somehow abstract values sometimes, and it's difficult to measure what it means to be ethical and moral. That's very important when it comes to fundamental freedoms and rights like the one we have been talking today. So thank you again for the perspective and the dimensions of the School of Magistrate and its continuous contribution in the field. Before going to the open discussion, I would like our colleagues to help us again with the third question and the last one of the poll. Should the right for privacy be conditioned in cases of protect national security, protect public safety, protect health or morals, protect economy, prevent crime or disorder, protect the rights and freedoms of other people? Somehow, colleagues has presented us with those criteria that somehow can serve as reasons for limiting and making not absolute rights, but relative ones. So I would invite you all to give a last contribution to the third poll. Each of the reasons or options that were presented has a specific weight when it comes to preserving the right to privacy. I think, I don't know if we have any judge colleague or any prosecutor colleague among us, but who can somehow confirm what's the level of disputes when it comes to the violation of the right to a private life, or even restrictions when it comes to protecting one of those reasons or options that we saw. Few seconds because we have only half of us that are following the event voting so far. So a last effort to have reliable results even in this question. Okay, with 48% of the answers of the votes protects the rights and freedom of other people, followed by 26% to protect national security, and then 13% prevent crime and disorder, 9% protect public safety, and 0% protect health or morals. So thank you for your contribution again. And now it's time for sharing experiences, having questions, giving opinions. It's an opportunity to have any specific question to judges or share anything that you think is of relevance for this session. It has been quite an experience with, although very limited in time, but very qualitative, I would say. So you are all invited you are all given the floor. Please raise your digital hand or your natural hand in case you want to share your experience with us. Erida, would you like to have the floor? Thank you.
Yes, thank you, Valbona. First of all, I would like to thank a lot and to express our gratitude as the hosting organization for the two honored judges of the Strasbourg Court, Judge Pavli and Judge Shuking, for their impressive speeches and for the case law that they have referred during this session, as well as for the Professor Mandrov from the School of Magistrate. It's a pleasure to hear you, and what I consider is the fact that more you are in contact with the case law of the Strasbourg Court, the more insecure you are, whether you have the necessary knowledge or not. And by hearing all the cases that were very diverse, as well as pertaining to consolidated democracies, I can say, like Germany, Sweden, Norway, Belgium, I think that we as Western Balkan countries have this need to better address this case law in our domestic courts before the prosecutorial and the judiciary system, as well as to push for better reflection in the case law of the domestic courts of the standards elaborated by the Strasbourg Court. We see this need as we, at the same time, see that there are a lot of judges and prosecutors in the cases that we as Albanian Helsinki Committee have submitted that refers in a continuous way to the case law of the Strasbourg Court. But still, this is a challenge because I think for elaborating and discussing for the Strasbourg Court case law, you should need a specific university. Even for the fact that the European Convention is a living instrument and anchored to the reality of the member states in which it applies. And this was also one of the cases that the Judge Pavli has referred to us when he said that the anonymity, being anonym in the media is somehow conditioned also by the level of the democracy, the democratic system in the country. So this is something that should be taken into account, especially when we are in the reality of the Western Balkan countries. And I have, in fact, two questions. I don't know if the judges will have the opportunity to answer them. More specifically, one of the questions refers to both of the judges. In your consideration, as the European Convention is a living instrument, have you seen significant turning points in the decision of the Strasbourg Court due to the social developments or new phenomena that affect the media sector and that are related with the Article 8 and 10 of the European Convention? If there is a specific case that you can mention that really is like a big U-turn in the jurisprudence of the court. And the second question is related to what Judge Pavli presented about the interventions of third parties in the online media, where the Strasbourg Court has revealed the need to have a fast and effective mechanism in order that online media controls inappropriate comments by the third parties. We had a discussion in Albania some years ago to intervene in the legislation to regulate this issue. But what would be the best option in your consideration, Judge Pavle, for this issue? Shall we have a specific law, or shall we regulate this issue by a code of ethics affecting media, or by statutes that media applies in this case? And we know as lawyers that the biggest concern when we regulate or check and control the comments of the third parties is the censor. What happens if a comment is removed unfairly, not because it violates someone's dignity or the Article 8 of the Convention, but because the editorial office does not like it? How difficult is, especially in fragile democracies as the context of the Western Balkan, is to keep the proportionality and to cut what is something that really affects the dignity, the privacy, and the family life of someone, and if something is done to censor a comment that maybe might have also public interest. Thank you very much.
Jolene, would you like to go ahead first, please? You're the guest.
Yes, took me some time to unmute. Well, thank you, first of all, for these important questions. I think they're very relevant, especially in the context of this this conference, of course. I would a little bit address the question relating to the living instruments, and of course the other was more specifically addressed to Darian. Yeah, with the expression living instrument, which the court has used quite a lot in its jurisprudence, it of course says that the provisions, that the rights reflected in the convention should be interpreted according to present day conditions, which makes the application of the rights more flexible. Just to mention an example, when the convention was drafted, of course, internet didn't exist. Where, for instance, Article 8 refers to correspondence, at that time, when the founding fathers of the convention drafted it, they were thinking of paper, of letters. But of course, nowadays, correspondence has a different meaning. So in that way, the expression living instruments makes it possible also to include aspects which are relevant in our today life, which did not exist at that time. Also, for instance, Article 8 contains the element home, while at the time when the convention was drafted, it was mostly seen as the personal home, where you live with your family. Later on in the application of Article 8, the court also applied this expression to company premises. So it's took into account a meaning of this element, which maybe was not in the convention when it was drafted. So this also, of course, applies to the elements of private life. You remember that there is a lot of case law about gender identification. Well, this is something which has developed over the years, and it's therefore important not to have a very conservative and closed way of interpretation. At the same time, as you rightly point out, this also makes it for domestic prosecutors and judges or authorities in general more difficult to predict how the Strasbourg court will look at the case when it finally ends up there. But which is very important to remember is that it's in Article 1 of the Convention, it is stressed that the human rights, fundamental rights as contained in the Convention, should be safeguarded by the domestic authorities, including the judicial authorities. So it's in the first place those authorities who have to apply and to safeguard the Convention principles, and only in a final resort, it's the court in Strasbourg who can be asked to address these issues. So there's also, space on domestic level to assess these rights, and I think it's important that domestic judges. I've been a domestic judge myself for years before I was elected to the Strasbourg court in respect of the Netherlands. Is that you dare to look at the principles and to apply them in the specific circumstances of the case. Of course, the court's case-specific case law gives guidance and provides you with the principles that have been applied. But at the end, it's the domestic authorities who will have to apply these principles in circumstances of the specific case. And that's important to remind that's, this is in the first place to the domestic courts, and I referred a couple of times to the margin of appreciation, where it concerns relative rights, so not absolute rights like the Article 3 prevention of torture. There is a margin of appreciation, and if it's demonstrated that domestic authorities, and including domestic judges, have made this balancing exercise and have provided in the reasoning of their judgments sufficient and relevant reasons, then the court will take all this into account when such a case finally comes up to the Strasbourg court. I hope this is a little bit an answer to your question. I'll pass the floor to Darian for adding some more answers. Thank you.
Thank you. I will just say very briefly on the living instrument. I think there's not a whole lot I can add, but on a specific issue, since I think Valbona mentioned the problems of mass surveillance, that one judgment that is quite anticipated by the Grand Chamber is one involving two cases, one against the United Kingdom, Big Brother Watch versus the UK, and one involving Sweden, Centrum för Rättvisa versus Sweden. And I think there will be a judgment coming out. I cannot say much about it, but I think it will be an interesting one, and it should be coming out in the near future. So keep an eye for those interested in surveillance. On the second question on the question of the models, regulatory models. Now, again, I think I need to start by saying, as the court has always said, that the models as such are not for us to judge. Now, of course, as an individual judge who's worked on these issues, I have my thoughts, but those are not so relevant. And it is for the national authorities, the national political and legal system to decide what model they want to follow. But of course, there are some constraints that the jurisprudence of the court puts, or some guidance, if you want, that the jurisprudence of the court provides in terms of how far they can go in terms of interferences or in terms of due process and so on and so forth. I would make just a couple of points. I know that there's been a long and complicated debate in Albania that is still ongoing. I would make the following points. First of all, everyone is grappling with these issues. Albania and the region is not on it. No one has the perfect answers. There are very complex questions about how to regulate this wild animal that is the internet, that is hugely beneficial in terms of democratizing expression in this century, but also has raised a whole range of new issues. And no one has the complete or the perfect answers. And you'll see that in Germany, for example, they've had a special law some years ago focusing on the big platforms. There was an attempt in France that was struck down by the Constitutional Court. There's been a white paper in the United Kingdom that has been in discussion for many years, and they still have not concluded. And the current government has not said whether they will bring a bill to Parliament or not. You know, there's other models out there. There's a number of models in Russia that the court has found, and other places the court has found problematic. I would say the following, that there seems to be a certain consensus that at least the big platforms have to do more than just wait for complaints. So that they need to have in place, they have the financial means and the ability, the human resources to do more to prevent their networks from being used to cause harm to others, to interfere with elections, to undermine democracy, and so on. We've seen that in Europe, we've seen that in the United States, and I think we can see that in practice they are doing more. I note, for example, that the German law that imposes higher requirements only applies to platforms with more than 2 million subscribers in Germany. So there is what seems to be an emerging distinction between the big global entities, which might be required to have more responsibility, and everyone else. And in terms of the regulatory models, I know that one of the issues in the Albanian discussion, at least, has been whether there should be a role for these intermediate bodies, administrative agencies that are sort of semi-adjudicatory, semi-judicial, but not entirely. And in that respect, again, it's a complex set of issues. I shared my presentation by email with the organizers, and you know, if anyone is interested, you can have a look at it. I've cited 2 Italian cases, the most recent being Edizione della Roma, which deals with the responsibilities and the procedures before the Italian Agente per Comunicazioni, Agicom, which is similar to many of the broadcasting regulators that we have in our region. So I think I don't have the time to go in detail, but for those of you interested in what role there might be there for intermediate bodies that are not an executive agency but are not a court and that fall somewhere in the middle, that might be some useful reading for you in terms of the case. Not everyone has the answers at the national level, and that means that the case law is even more delayed because it takes a certain number of years for cases to go through the national systems before they go to Strasbourg. So we have a little bit of a lag, as is appropriate, I think, in responding to the latest issues at the national level. I see that there is a question on the blog from our friend and colleague Lutfi Dervishi on the impact in the region of the Delphi verdict. I think it may be more appropriate for the colleagues from the region to tell us what they consider that the impact of Delphi has been so far. Thank you.
Thank you, Judge Pavli. That's shocking. We have one of our participants asking for Elvira. The floor is yours.
Hi, Alvana, thank you. I'm not sure whether you're going to answer, somebody is going to answer the Lutfi's question, or should I just move on with what I wanted to say?
Oh, you better start with the purpose of your request first, and if you have anything specific related to Lutfi's question, I would appreciate that as well.
Yeah, so my question wasn't specifically about anything that Lutfi mentioned here about the Delphi verdict, but anyway, I'll just be brief here. Thank you very much, everyone, for sharing all these very important things and knowledge about and experiences about regulation, and also we are talking about partly about self-regulation, which is something where I'm personally very involved and very passionate about, especially when we are talking about ethics. So I wanted to share one example actually with you. I was asked to share one short video, one TV report from Albanian television, where we can see a couple of different questions about and dilemmas about concerning this issue of ethics in the media. It's very good to always very good to talk about different verdicts that exist that can definitely serve as role models, or they can serve as maybe basis for some kind of regulation if it's needed. But when you open the media, when you consume the media every day, there are so many different examples of media reporting that are problematic, but maybe they are not cases that you should, put to trial or whatnot. But I would just like to raise a question about whether people are sometimes maybe not aware of the possible damages of also to their private life, and also about the ethical damages. Definitely we have a freedom of media to report about different topics here, which is not questionable here. But having this freedom, does it mean that always you have to practice it or consume it as a journalist? Or maybe obviously all these people, including the people who are taking care of the boy right now, they are willing to talk to the media. They agreed to be filmed and so on. They agree that their story is public like this. But I'm just wondering, I'm always wondering about the role of journalists, whether maybe it's not, journalists are not too aware of the damages that that this kind of reporting might cause. Anyway, there was one example also in Bosnia and Herzegovina a couple of years ago, where there was a fire in Sarajevo in one building, and somebody was filming the window from where a woman was screaming, and then you can see on this video that the fire is so big that the woman stopped screaming. You can conclude that she died in the fire. And this kind of video was filmed and by some user on YouTube, and then all the media republished it, saying, oh, this is a video that was aired on YouTube. And a criticism from our side, from Media Center side, was, okay, maybe it is in public space, it's on YouTube, but what is your role as a professional journalist? Are you legitimizing that kind of breach of privacy, or unethical report? Are you supporting this by your unethical reporting? And so just to be clear about my question is whether what do we actually do with all these republished and spread like feathers in wind? The examples of okay, there is rights to be forgotten, but how do you practically use it if you're not aware of maybe not even being aware of your rights being violated, or your dignity being kind of violated by the media? Thanks.
Judge Pavli or Judge Shuking, any consideration on the question, even though you tackled quite interestingly the issue of the right not to be forgotten. Yes, thank you. Just joking.
Yeah, very briefly, because of course I saw some images, but I don't, of course, not at all the context of this thing. But I think you raised a very important issue, and that's the issue of awareness. And I think this is something which, which it would also be a task of the authorities to make people aware of well, the consequences of being exposed, and this is of course something which is not very a legal aspect, but more a general aspect. As I said in the beginning of my presentation, the existence of all these possibilities. I mean, on the one hand, they're marvelous. They make us having this conference online today. On the other hand, there are also legal questions of which a lot of people who are using social media or other forms of like in this TV presentation, that people are not aware that all these it's not just once on television, but you can trace it through the internet. It's there, and it has in that way the existence of internet and all these possibilities has transformed our social life, our societies, and people are not aware of that. So I think this is an important thing to keep in mind. But as regards your question about ethics and journalists, I think whenever you're dealing with such sensitive issues, journalists should always first ask themselves, what is the legitimate public interest of broadcasting this issue, or there could be, I mean, there could be a very important discussion going on abandoned children or whatever, but at least you should firstly think about this issue. Is this a legitimate, is this, demonstrating this, making this rapportage, is this something which is of legitimate public interest? And of course, when it concerns children, I think children in convention terms, in case law terms of the Strasbourg Court, children are considered an extremely vulnerable group and in need of special protection. So, when it concerns children and they have a huge future ahead, I mean, they're just, in the beginning of their life, and right to be forgotten for them has maybe another impact than to a person who is of age. So I think these are indeed also issues for the journalists to be aware of. But I think also in general, our societies need to be informed about how this works and what are their rights, and at the same time, what are their obligations? Because what I wanted to transmit with my presentation is that also for journalists and for media in general, I mean, you have special protection under Article 10, but rights always are linked to obligations, which is also reflected even in the text of paragraph 2 of Article 10 of the Convention. I think this is all I can say more in general, because of course I can't say any specific, can't go into the specific of this case, but I hope it's addressed a little bit the important dilemma and issue that you raised. Thank you.
Thank you, Judge Shuking. We have exceeded our timeline, but we have one last request for intervention. One of the participants, Thea. She would like to share her experience on the Delphi case and also has a question.
Thank you. I'm sorry. First of all, thank you for the organizers for the invitation. I'm from Human Rights Action in Montenegro. This is excellent opportunity. I'm sorry I wasn't able to come to the first part, but my colleague was present. Regarding Delphi case, if you would probably, if some of you would be interested, Montenegro has recently adopted a media law and regulates this issue in Article 26. Whoever is interested, I would be very happy to send the exact article, it basically calls for removal of the comment with illegal content at latest within 60 minutes from notification. So notify and remove. And before that, this issue was regulated by the Ethical Code of Journalists of Montenegro. Whoever is interested in this further, please write me to hra@t-com.me, but I will be in contact with the organizers. The other issue I wanted to raise, I'm sorry for taking now more of your time, but I think it would be interesting, as most of us present at the panels are women, it actually relates to gender hate speech. And this is an issue that has been, it happened several years ago, but now we've, following the change, the first substantial change of government in Montenegro in August last year, we're facing several sexist, misogynist cartoons depicting women from public life, mostly politicians, so from political life, including the government. Those cartoons or very explicit drawings appeared in social networks, but then were picked up by some portals. And so they're either explicit drawings or collage photos attempting at satire, but obviously stepping over the line. Now, you would have to trust me on that. I mean, I don't have these images prepared now to share. Now, our state prosecutor responded to this challenge to one of those cases, which involved the government minister, by qualifying it as a crime of violation of the reputation of Montenegro. And this crime prohibits usually the violation of flag symbols, other state symbols, entails possible prison penalty. So we in general against this criminal offense. On the other hand, obviously, we're in favor of removing the speech that is, I would dare say, really goes into hate speech on a gender basis from the system. And we're preparing an article about it. So if possible, if there is still time, and if the honorable judges or any one of the colleagues has a comment on this regarding Strasbourg law, regarding what is going on before the court that we do not know about, please let us know. Thank you.
Thank you, Thea. I would ask for the understanding of Kleidisa. She wrote a long question in the chat, but I promise that we'll give her a reply via email, because it's closely related to the domestic legal framework. We have gone considerably beyond the limit time, and Kleidisa, I really hope your understanding on that. I think so. You have a reply also in the chat, so we can follow that later. I think we have come to the end of this session. A special thank you to our panelists, Judge Pavli, Judge Shuking, Professor Mandro. It was a great pleasure hearing you today and sharing with us what are the challenges in protecting the freedom of expression, privacy, finding a balance, the golden one, which is very, very difficult in the digital era, because we have different pressing issues confronting each other, each one fighting for its own rights, but we all have to understand that this balance somehow means that one of the rights shall prevail. So I would invite all the human rights defenders, all the journalists that were with us today, all other colleagues that are part of these two very important freedoms and rights, and protect them and implement them, to be as careful as it is required by the standards. Only by establishing first standards, only by consolidating the practice, we'll have the chance to at least ensure a level of protection which can be enhanced. But we need, first of all, a lot of ethical behavior. We need to respect what's the legal framework. And of course, a continuous training would be the best mechanism to get into the developments and know what's the best practices from the European Court of Human Rights, from the region. And I'm closing with a big thank you for the organizers, as well for the participants who dedicated a very precious time from there. It's still Friday. We are still within the working hours. If Erida has something to say.
No, I cannot add anything else above what you have said, Valbona. Thank you very much for the moderation. Thanks a lot.
Thank you. It was my pleasure. Stay safe, everyone, and have a great weekend. Thank you very much. Goodbye.